This is a lecture from Open Tuition. For the free lecture notes that go with this podcast, please visit opentuition.com.
Page 74, name change. Maybe compulsory, maybe voluntary. Compulsory is obviously where you are made to change your name. You are directed that you shall change your name. And if it becomes apparent to the registrar that your name is offensive or misleading, or George Bush, if it becomes apparent that your name is offensive, then the registrar will direct you and say you have to change your name. It's upsetting too many people. Or you may be compulsorily required to change it in the case Buttercup Margarine Company. But it's also possible, let's just go through the bullet points. You may be required to change by order from the registrar or by order from the court. In case Ewing and Buttercup Margarine was by court order. Within 12 months, if the company has been by mistake registered with a name too similar, which would be the Buttercup one, or within 5 years if misleading or offensive information was supplied. You can be required by the registrar or the court to change your name at any time. There's no 5 years or 12 months restriction. There's no time period. If at any time, if the use of the name is likely to cause harm to the public. Tell me what you understand by harm to the public. Offensive, yeah, maybe. I mean, it's difficult, isn't it? Harm to the public. Can you think of me creating a company which is going to cause you harm? Damage? Sufferance? Creating obligations upon you which you didn't want? I mean, it's very difficult to think. And in fact, harm to the public is broad enough to allow the court to interpret harm to the public in pretty much any way they want. It lacks definition. So it's just an open-ended availability to the court to require you to change your name. Change of name is by special resolution, but you know what is required by special resolution. It's a 75% majority in a general meeting of the members. It's a 14-day notice, copy of the resolution and the amended constitution, because the constitution will say, these are the articles of ABC Limited, and you're now changing the name, so it's now the articles of CDE, brackets, formerly ABC Limited. So you need to send in a change of constitution to the registrar within 15 days, and the registrar will issue a new certificate of incorporation. But just because you've changed your name doesn't mean it's a new company. So any legal process which is already in operation against the company is still continued into the company with its new name. Any contracts which the company entered into in its old name are still valid contracts in the company in its new name. It's no different, is it, than a woman who gets married changing her name. On the basis that the contracts that you entered into as a single woman, they don't cease just because you've got married. And so on the basis, on a parallel or typical or similar basis to that, then you can understand, I think, that contracts will continue. And nothing actually changes, does it? It's just the name that just changed. That will do then for page 74. 75, the objects of a company. This was the clause in the old memorandum that used to take half a day to lecture, and then it got streamlined. And basically, if you imagine, again, it's a difference between a company and a human. We can do anything we want. So long as it's legal, we can do anything we want. And some of the things we may choose to do may be offensive in the minds of others, but there's no restriction other than the legal restriction. But a company historically, because it's artificial, a company was only allowed to do what it was specifically allowed to do. And that's very restrictive. So over a period of years, we developed what was called the multiple objects clause. And instead of it being a 3-line objects clause, the company is formed to provide accounts and situation services. It then developed into not just one 3-line clause, but a clause which was maybe 3 pages long. The company can do this and this and this and this, and pretty much anything else would it choose. Well, the purpose of the objects clause, this artificial restriction, disappeared, because draftsmen of constitutions made it so wide that in effect there was no limitation. So the legislature, the Parliament, passed the Act, I think it was 1980 or 1981, it might have been the 1985 Companies Act, which said that a company can effectively do anything. Nothing, it says nothing in a company's constitution shall affect the validity of a contract that the company enters into. So no restriction, even if a company is operating beyond its powers. The expression beyond its powers is, unfortunately, it's a Latin expression that you must know, ultra vires, beyond its powers. And if a company operates and enters into a contract beyond what it is allowed to, this does not affect the validity of the contract. The contract is still good, even though it's gone beyond what the company is allowed to do. Nothing in a company's constitution shall affect the validity of a contract entered into with an innocent third party in good faith. And the effect of that is that the innocent third party who deals with the company acting in good faith is protected by the law. The company can't defend itself and say, this contract that we've entered into we shouldn't have done and therefore it's not a good contract. The company cannot say that. The third party can always rely on the validity of that contract, but the company can't. The company can't rely upon that acting beyond its powers as a defense, because the company knew what its powers were, and therefore the company is not allowed to sue on a contract or beyond its powers, but it may be sued. Okay, protection of the public. So since 2006, companies can do anything so long as it's legal. The same as us, the same as we can. Companies can do anything they want. So since 2006, the only reason to mention objects in the articles is to mention them restrictively, to simply impose a restriction. What we used to have was the company can do this, this and this, and therefore if it wasn't mentioned, the company couldn't do it. So we had to specifically identify what it was allowed to do. Now, the company can do anything unless it is specifically prevented from doing. If a company tries to ignore the restriction, that's called acting ultra vires, acting beyond the powers. And a member can object because the company is created to do this or be restricted by this. And if they ignore that restriction, then a member can take action in court to prevent the company from pursuing this ultra vires activity. The case is a case called Ashbury Railway Carriage and Iron Company, and Riche. This is a company which was formed to manufacture railway carriages, railway rolling stock it's called, to manufacture railway carriages and act as mechanical engineers generally. And an opportunity came their way to buy and operate a railway line in Belgium. And the directors thought it was a good idea, we can make some good profits on this. So they put it to the membership and said, do you approve that the company shall buy and operate a railway line in Belgium? And 94% of the ordinary shareholders and 96% of the preference shareholders all agreed and said, what a wonderful idea this is. And Riche, just an individual ordinary member, he only had 5 shares. He said, no, you can't do this. It's not allowed by our constitution. And he took it to court and asked the court to grant an injunction to prevent the company from buying and operating a railway line. Why? Because the company was formed to make railway carriages, not to operate railway lines. The company said, well, it says in the Constitution that we shall make railway carriages and act as mechanical engineers generally. And operating a railway line could be classed as mechanical engineering generally. But this brings us back, doesn't it? This brings us back to interpretation of statute. Cats, dogs, and other animals. Rubies, diamonds, emeralds, and others. Where there are specific words followed by general words, you can only include within the general matters which are similar to the specific. So the manufacture of railway carriages and other things, you can only include in the and other things what? What's similar to the manufacture of railway carriages? Who? Yeah, it matters as well. Give me something in the same class as the manufacture of a railway carriage. I mean, a locomotive is railway rolling stock. That was the precise words. The only thing I could think you could possibly include would be trams. A tram would be similar, wouldn't it? Because it runs upon specific lines on the ground. But even a trolleybus would be different. So actors, mechanical engineers generally could only include things of the same class. Eius dem generis is the rule that you were about to tell me. Eius dem generis, things of the same class. And Riche, even though he's only a tiny shareholder, Riche won his case and prevented the company from buying and operating this railway line in Belgium. I've already mentioned both of these next 2 points. The validity of a transaction shall not be called into question on the grounds of lack of capacity. Just because it doesn't say within the Constitution that I can do something, it doesn't mean that I can't do it. So the validity of any contract entered into with a third party acting in good faith, the next point, the powers of the directors to bind the company shall be free of any limitation created by the company's constitution. The directors put the company into contract. They're operating either beyond their powers individually or beyond the objects of the company, the powers of the company to enter into contracts. Doesn't matter. An innocent third party will be protected, acting in good faith. You don't have to prove good faith. Good faith is presumed. You don't have to ask. As an innocent third party, it is not a requirement that you should ask the directors, are you allowed to enter into this contract? There's no requirement to inquire. If you do ask, and they tell you the truth and say, no, we are acting beyond our powers or beyond the company's powers, do you still want to go ahead with the contract? Then you're acting in bad faith. So you wouldn't be protected. If you ask and they lie to you, because I know it's difficult to believe, but people do lie. If you ask and they lie to you and say, yes, it is within our powers, even though it isn't, the third party is protected. But the safer thing for a third party to do is not ask. If you don't ask, then good faith is presumed. But it only applies to third parties. These protections, they only apply to third parties. They don't apply to the members of the company. Why? Because the members of the company are deemed to have a copy of the company's constitution. It's their company. They should know what the company is allowed to do, whereas an innocent third party doesn't have available a copy of the company's constitution. Good faith is presumed unless shown otherwise. No third requirement for third parties to make inquiries. So a third party is protected, but the company can't sue on a contract which lies beyond the company's powers. The third party can sue the company, but the company cannot sue the third party.